If you're thinking about buying or selling a property, then one of the issues that you need to be very much aware of, and you need to perhaps do a little bit of advanced planning about, is the question of planning. Obviously, if you're buying a house and there's any issue or any problem in relation to planning, or any extension or any development that might have been carried out, then you can walk away and buy a house in a different house essentially. But if you are the vendor, if you are the owner of the property and you have your heart set on selling your property and moving on, well then any problem to do with planning is going to cause you some serious grief. I suggest a three-step approach to planning problems that might arise. And to put it in context, the planning difficulty in relation to a house could be something to do with, for example, the construction of a garage. It could be an extension. It could be a porch to the front or the rear of the house. It could be perhaps a greenhouse. It could be a garden shed. Indeed, it could be an unauthorized use. For example, the conversion of a front room into some sort of a meeting room or surgery, for example, or something of that nature. So planning has a very wide definition in the planning laws in Ireland, and that's the first thing you need to be aware of, and that is something that you need to accept might pop up when you are going to sell your property. So let's take a look. First thing, you need to find out whether development was carried out or not. If a development was carried out, then there's planning permission is required unless it's exempt. Now, if it was done pre-1963, in other words, prior to the commencement of the Planning Acts in, I think, October of 2000 or of 1996 or of 1964, if the development was carried out then, prior to that, then the development will be exempt and there's nothing to worry about. There are other exemptions then as well. For example, a local authority would have exemptions in relation to carrying out development in its local authority area. So if Dublin Corporation or Dublin City Council or Kildare County Council or Meath County Council built a house or perhaps a replacement dwelling arising from a road widening or something like that, well then no planning permission is required, because once they build the property in their own jurisdiction, as it were, their own planning area, then they are exempt. There are a number of exemptions and they all arise they're set out in the Planning and Development Act of 2000. Now, if there was a development and if it's not exempt, then there's a couple of things you need to consider. One, it's a fairly drastic solution, but it is a solution nevertheless, and that is to demolish the unauthorized structure. That may or may not be possible, and it may or may not be prudent. Second solution is to apply for retention permission. There's two difficulties with retention permission. One, there's no guarantee that the permission will be granted, and two, it's going to be a slow process. So if you get your house sold and you discover then that there's a problem with planning, then looking for planning permission, retention permission, it's going to be such a slow process that it's unlikely that your purchaser is going to hang around. Finally, there's a thing called the 5-year or 7-year rule or 7-year rule. It's set out in the Planning and Development Act of 2000 in section 157. And it basically says that if the planning authority has not served you with a notice or taken any action or proceedings against you within 7 years of the unapproved, unauthorized development, well then they can't take any further action against you. You might say that's fine. If it's after 7 years, then we're in the clear, we've nothing to worry about. But that's not the case. It simply means that the local authority cannot pursue you, cannot serve a notice. It doesn't mean that you get planning permission by default. You don't get planning permission by default. What difference will that make down the line? One situation or one scenario which could occur is if there was, for example, a road widening scheme and there was compensation to be had for losing perhaps this particular structure, then if it was unauthorised and if it didn't have planning permission, then no compensation would be payable. So that's a problem. There's also a problem obviously for a purchaser who's borrowing money from the bank. The bank is going to be concerned about an unauthorised development, and the solicitor is also going to be concerned. In other words, the solicitor acting for the purchaser, because he or she has to certify title for the bank. If that's the case, he's going to be writing to the bank saying, look, I'm going to have to qualify my undertaking because here's the situation. There's no planning permission for this garage or massive garden shed or massive statue out the back or porch out the front or greenhouse or conservatory or whatever. It was built 10 years ago. Nothing can arise insofar as the council pursuing or serving notices, but nevertheless there's no planning permission, and there won't be, or else there will be only after we apply for retention permission. So that's one broad category of problem that might arise in your property sale or in your property purchase. It's probably a bigger problem though for the vendor or for the seller, because obviously they only have the one house and they are anxious to sell it and they need to solve the problem, whereas the purchaser can move on and simply buy another property. The second problem or second area of problems you need to be concerned about is building regulations and bylaw approval. Is the property located in an area where bylaw approval was required? If it was, well then there's no certificate of compliance with bylaw approval. You might be able to get an architect or an engineer to certify that, even though no certificate was issued at the time that the work was carried out from an inspection that he's carried out. From an inspection, he takes the view that had a certificate or had approval been applied for in respect of bylaw approval, then there wouldn't have been a difficulty. The other issue then is to do with building regulations. Building regulations came in 1990. Again, there's either a certificate of compliance with building regulations or not, and if a building regulations applied to the development, then there is a requirement for a certificate of compliance with building regulations, and if there's no certificate of compliance with building regulations and building regulations did apply to the development, then quite frankly there's no solution. Second or thirdly then, you need to be concerned about architects' certificates of compliance with planning permission building regulations. So all developments, unless they're exempt, will need a certificate of compliance with planning permission and a certificate of compliance with building regulations. And even if you're claiming that the development was an exempt development, you'll still need a certificate from an architect or an engineer who will certify in his opinion that the development was an exempt development, and he'll set out then in his certificate the basis on which it was exempt. In conclusion then, I'd be saying to you that planning is something that can trip you up. It can trip you up, particularly when you're selling. Sometimes there's solutions, sometimes there isn't solutions. I've looked at three broad categories or three ways to approach the problem and the different types of problems that might occur, whether there is development or not, whether there is an exemption or not, whether there are certificates or not. So they are the type of things that you need to look at, and again you may rely on the 7-year rule in respect of an unauthorised development, or you may knock the development, or you may seek retention permission, but retention permission obviously is a slow process and there's no guarantee of success. Then the other issues are to do with building regulations. If a property was carried out or development in say the year 2000 or 2010 or 15 and there's no certificate of compliance with building regulations, well then strictly speaking there's no solution, because nobody can certify that the property was built in accordance with the building regulations. Anyway, I hope you find this video useful. If you do, I would appreciate if you gave it the thumbs up down below, and you may be interested in subscribing to my YouTube channel. Thanks a lot.